Thank you so much. And I accept this medallion as a symbol of the presidency of William Mitchell College of Law, and I do so with a full sense of the magnitude of my responsibility to this great college. I'm deeply grateful for your trust, and I pledge to work wholeheartedly for the greatest good of this institution. And I'm truly grateful to all of you for coming tonight. Chief Justice, incoming Chief Justice, members of the judiciary, our trustees, our representatives from our sister institutions, my colleagues on the faculty, staff, alumni, students, and my family. Thank you so much. I want to talk a little bit about what I think is terribly important for this college. And I'd like to start by asking you to think back with me about 45 years this month to Birmingham, Alabama, April 1963. State Court Judge William Jenkins has just signed a sweeping injunction, an ex parte injunction, prohibiting 133 named defendants, including Dr. Martin Luther King, from engaging in any kind of protest, including conduct commonly known as kneel-ins in churches. The injunction is served on Dr. King at 1 a.m. in the morning, and later that night, a lawyer from the NAACP, Norman Amaker, who 30-some years later would come here to William Mitchell as a visiting professor, Mr. Amaker advised Dr. King that he thought that the injunction was unconstitutional because it infringed the right of assembly and First Amendment rights, but that nonetheless, under the law, if Dr. King violated the injunction, he would be subject to arrest and punishment. But nonetheless, Dr. King persevered, and the next day, he led a march of 1,000 people. He was then arrested along with 52 others on orders of Bull Connor. About 4 days later, he was sitting in the Birmingham jail, and he wrote a letter that we now know as the letter from the Birmingham jail. And in that letter, he responded to a letter that had been published a couple of days earlier by 8 white Alabama clergymen. And these clergymen had called King's work unwise and untimely. They urged patience and negotiation. King's letter embraced the idea of negotiation, but he observed that we know through painful experience that freedom is never voluntarily given by the oppressor. It must be demanded by the oppressed. Meaningful negotiation would come, he said, but only as a result of the tension and the crisis provoked by direct action, by nonviolent demonstrations. So here's the lesson I take from Dr. King's letter. Justice isn't simply an idea. It's not an abstract value. Justice comes from real work in the real world by real people. And it is in light of that understanding, that I understand our mission here at William Mitchell. We serve the law. We teach it, study it, practice it, and work to make it just. We serve the law because the law is central to our security, to our peace, to our prosperity. We must have law, but we must have justice as well. And what I learned from Dr. King is that it's not enough to think about it. It's not enough to study it or theorize about it. We must practice it. We must be engaged. We have to roll up our sleeves, and we have to make the law work to serve justice. This takes grit, perseverance, courage, and it takes skill. At Mitchell, this understanding is at the core of our mission. That is why, as we take this law school into the future, I am committed that our educational program will continue to be built on respect. Respect not just for the law, but for the practice of law. To attain justice, we know, we need more than grand ideas and noble ideals. We need also strong advocacy and gritty hard work. This is, in my mind, the heart of our mission here. And this is not, my friends, a bold new direction for William Mitchell. It is a pioneering 108-year mission. It is the soul of this school. In 1900, Mitchell was founded on the noble principle of access. Access, to be sure, to a professional life of accomplishment, to upward mobility, to prestige, but access, much more importantly, to the courtrooms, the boardrooms, and the legislative hearing rooms where our law is made and where justice is created. And it is the legacy of this passion for access that is our endowment. It's a group of alumni, over 10,000 strong, whose work on the large stage and the small has made and will continue to make an enormous and enduring difference in our community. If not for Mitchell, would Warren Burger, class of 31, have become the 15th Chief Justice of the United States? Would Lena Smith, class of 21, have become the first African American woman to be admitted to the bar of this state? And would Peter Popovich, class of 47, have been the first Chief Judge of the Minnesota Court of Appeals, and later one of 11 Mitchell alums and a Chief Justice of the Minnesota Supreme Court? And would Eric Magnuson, class of 76, have been chosen to serve as a law clerk for Douglas Amdahl, then a district court judge, later Chief Justice, class of 51, and then Mr. Magnuson himself become the choice of the governor to be the state's 20th Chief Justice. And if not for Mitchell, would Rosalie Wall, class of 67, have become this state's first female Supreme Court Justice, followed closely by Esther Tomjanovich, class of 55. The two of them thus becoming one half of the first female majority state Supreme Court in the country. And what about Regina Chu, Judge Regina Chu, the first Asian American female Minnesota District Court Judge, Lori Swanson, the first female Minnesota Attorney General, Christopher Tao, the first Hmong lawyer in the United States, Hassan Ali Mohammed, the first Somali law graduate in Minnesota, and Jessie Nicholson, the first African American woman to head a legal services program in Minnesota.